Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma in Paralegal Practice, Dipp. BLEPOO1 Clinical Course. Block-1 Guide to Legal Research and Writing. Unit 3 Legal Writing. 3.1 Introduction. This unit will introduce you to the basics of good writing and how to write effectively for a legal forum or client. You will learn the essential elements of good writing and how they are applicable to legal writing in general. The elements of who the audience is and why you are writing a particular document will influence the manner of writing. Clarity and simplicity are emphasized, and tools to achieve this will be taught to you. You will learn how to prepare for legal writing, including organization of your research for purposes of writing, and how to cite material sources of law. The unit will introduce you to three types of documents, viz. the case brief, legal memorandum and legal pleading. You will learn the approach taken towards each of these types of legal writing. 3.2 Objectives. After going through this unit, you should be able to develop writing skills, apply these lessons to legal writing, identify the types of legal writing and the differences, and utilize your legal research skills and translate them into the written medium. 3.3 The Essentials of Good Writing. The skill of writing well is of great importance in the presentation of legal issues. You will be required to translate your research and findings on the law into written form, either as an opinion for the client, as a representation to the government, or as pleadings before a court. For any of these purposes, it is crucial that you are able to write in a clear, precise and logical manner. The notion that legal writing is old-fashioned and not understandable by the layperson no longer holds true. It is an essential part of your legal training and basic legal skills as a paralegal that you are able to write in an effective, yet simple manner. While the previous units have taught you how to approach the law and legal system, as well as how to research properly, these skills will not be of use if you are unable to translate this understanding and research into legal writing. The principles in this unit are applicable to legal writing in any language. 3.3.1 What and why. There are 2 points that you need to keep in mind when you are commencing with your writing. First, what is the purpose for which you are writing? Second, who are you writing for? The first point refers to why you are putting your arguments and legal analysis into writing. In case you are giving your opinion on a particular issue to your client, you will be required to explain the problem and the application of the law to that problem. You will need to highlight the strength and weakness of her position under the law and explain how it would impact the case. The other situation in which you are required to write is to present your case before a court. In such a situation, you will need to highlight the argument that would favor your client and argue this persuasively in your brief or pleading. When writing, you must be sure of who your audience is. When you are preparing pleadings for a court, you can use legal terminology and presume that this will be understood by the court. In case you are preparing an opinion, you will be required to present your argument in a manner that it is understandable and accessible by your client. This, however, does not mean that you simplify legal argument to such an extent that the meaning of the argument is lost. The argument must not be sacrificed in the process of writing. 3.3.2 Clarity and Simplicity. While writing, you must be clear and precise, regardless of whether you are writing a legal document or an essay on another subject. Further, keep sentences simple and not overly complicated. Avoid long sentences, and make use of punctuation effectively. For example, Sheila and Raj went for a walk and on the way found a lost puppy that they returned to the neighbor as they knew the puppy belonged to him. A more effective way of saying this is, Sheila and Raj returned the neighbor's lost puppy that they found while on a walk. Another point to remember is to use active voice, rather than passive voice, unless necessary. For example, it was decided by the court that X had committed murder can be better put as the court decided that X committed the murder. Also, when the subject, the verb and the object are placed in sequential order in a sentence, it is easier for a reader to understand. It is also important to understand the words that are used. In case you have any Doubts regarding the meaning of a word, legal or not, you must check this in a dictionary. In case you are confident of a simpler word that conveys the same meaning, use that word instead. While writing, always organize your writing into paragraphs that are numbered. This, along with the use of headings and subheadings, makes a document easier to read as well as refer to later. 3.4 Legal writing. Legal writing is similar to writing any other essay or document in the basics that are essential. However, there are some differences in the manner and method of writing, as well as the preparation that is required prior to writing. 3.4.1 Preparation and organization. A first step in the course of legal writing is that of preparation and the work that you put in during the course of the previous stage, i.e. that of legal research. Prior to writing, it is helpful for you to organize your thoughts and arguments based on your research, in the form of an outline. This is essentially a well-planned list of issues, divided into sub-issues in accordance with the research on the point. For example, research conducted on the crime of genocide could be outlined in such a manner. Example of outline. I. The crime of genocide. A. International law. B. Domestic law. 2. Definition of the crime. A. Destruction of a group. B. Intention to destroy. C. Modes of commission. Once the preliminary research is completed, and the outline is prepared, it will be easier to put the arguments and the research material into written form, either as memorandum or pleadings. Once you have started writing in accordance with the outline, you might find that either you have not done enough research on a particular topic and will need to further research a particular area. Further, you may also find that there are new issues that require further research as well. Once this is done, you will revisit the outline, and might need to reorganize the list of issues, either in terms of more sub-issues, as well as further research material that needs to be added. This is one of the important outcomes of the process of putting your legal research into writing. The loopholes and gaps become more evident and you are in a better position to strengthen your legal analysis and argument. Look at the screen. Figure 3.2, Phases of Research and Writing. Once you begin writing, you must keep in mind the above-mentioned points regarding good writing in general. While writing specific types of legal documents, such as case briefs, memoranda and pleadings, the specific instructions in section 3.5 below will be useful. However, regardless of the type of legal writing, the basic rules of clarity and simplicity should be kept in mind. 3.4.2 Citing to authority. An important part of legal research is the ability to identify sources from citations, and to use the correct citations for authorities when citing them. This significant component of all types of legal writing involves citing authority and the use of authority in argument. There are two main points to remember here. The first relates to the weight of the authority that you cite, which has been discussed in Unit 1. The second relates to the manner of citing of this authority and some of the rules in relation to it. While some of the modes of citation have been explained, along with the sources in Unit 2, we will now examine how to use these in legal writing. Usually, when referring to an authority, whether primary or secondary, it must be cited in the written document. This is related to the idea that the reader or judge knows the exact source you are relying upon, and the reader can herself check that information firsthand. Further, an idea must be credited to the author of the idea, and no one else should take credit for this. This is a rule against plagiarism, or copying another's idea without due acknowledgement. For both these reasons, it is essential that authorities be referred to. The manner and method of reference can be by footnotes or by endnotes. Footnotes are present in the same page of the document, while endnotes appear at the end of the document. Footnotes and endnotes are numbered consecutively and appear in that order. For example, look at this excerpt. Look at the screen. Figure 3.3, Footnoting Example. This is an example of how footnoting would appear in an essay or other legal writing. In some countries, there is a standard method of citations, in order to bring about uniformity and consistency in how authorities are referred to. A common style that is used is called the Blue Book style, which has its origins in the United States of America. Most journals and publishers have their own style sheets that provide the format that needs to be adhered to. While in India there is no standard style that is used, it is better to use a consistent style of citation. This means cite all books in the same way, for example, and does not mean that a book should be cited in the same manner as a journal article or a case. Cite all books in the same manner, all articles alike, etc. While this has been discussed in the previous unit, a template is provided to help you cite in a methodical manner. Cases, name of parties, year, name of reporter, page number. Books, name of author, name of book, publisher, place of publication, editions. If any, year, page number. Articles, name of author, title of article, name of journal, issue or volume. Year, page number. 3.5 Legal Memorandum and Pleadings. There are essentially 3 types of legal writing that you will be required to undertake. These are the case brief or summary, the legal memorandum, and legal pleadings. While all 3 involve legal research and writing, they are different in their aim as well as scope. We will examine all 3 types of legal documentation and how to approach them. 3.5.1 Case Brief, Summary. A case brief or summary is a synopsis of a case you have read, which contains all the relevant information and analysis of the case. This is an extremely useful tool not only in furthering your understanding of an issue or area of law, but also in helping you in legal research and analysis. There are minimum requirements that must be fulfilled in order to write a comprehensive and useful case brief. These are the main points that you must keep in mind and include while writing the brief. Identification of the case. This includes information such as the names of the parties, citation of the case, level of the court, date of the decision and the judges. Please keep in mind the method of citation as discussed in Unit 2 previously. Facts of the case. The facts of the case should not be overly descriptive. Do not copy the facts from the actual case. Instead, read the facts and then summarize them. However, you must be careful that you do not omit material facts in the effort to summarize the facts. You must also be careful to keep to the facts on record and not introduce any facts that have not been discussed in the case itself. Procedural history of the case. The procedural history of the case contains details of how the case has reached this particular forum. It will involve describing the previous stages of the case and the decision at each stage. For example, if this is a case before the Supreme Court of India, please note whether it came on appeal from the High Court, if so, which court, and what the decision was at the level of the High Court as well as the lower court. Issues and decision of the case. In this section, you must correctly characterize the issues that have arisen in the case, and the decision based on those issues. Keep this to the point, and provide a paragraph for each issue and decision. Reasoning, rationale, ratio and obiter. In this section, you must describe the reasons for the decision. In the previous section, you have indicated what the issue is and what the decision is. Now you must explain the court's reasons for arriving at its decision. In so doing, you will need to explain the rationale of the court. Most important, as you learned in Unit 2 previously, you must elaborate upon the ratio decidendi and the obiter dicta of the court. Assessment. This is the section where you evaluate the decision of the court. You must do so on the merits of the case itself, and also evaluate it in the context of other cases. On the point. This is a complex exercise, as it will require not only an analysis of the case, but also of case law on the point. You will assess how this case stands up with regard to another case that is similar but decided differently, and what are the distinguishing factors. Also, which decision you think is correct and why. This requires a good understanding of case law on the point. In conclusion, writing a thorough and comprehensive case brief requires a great deal of effort. You must read the case as many times as you need, in order to get a good grasp of the relevant details. You might find that once you have written a draft of the brief, and go through the case again, you may have missed important points that must be present in the brief. It is recommended that once you have a draft of the case brief prepared, you must read the case again. This will ensure That you have a thorough understanding of the case, and that this is reflected in the written case brief. 3.5.2 Legal Memorandum. A legal memorandum is a rather different legal document from that of a case brief. The aim of a legal memorandum is to put together the legal research done on a topic in a cohesive manner, presenting a complete picture. You must keep in mind that a memorandum is not a document that advances a particular argument or pleading. It instead looks at the entirety of the legal arguments, presents these, and comes to a conclusion. It is meant to be more informative on the state of the law, rather than advocating a particular position. A legal memorandum is usually written in the context of a particular dispute that is either about to enter litigation, or is part of litigation. It might also be for the purpose of advising a client on a particular course of action to take, without any litigation having commenced. The legal memorandum serves as a document that explains the legal position better, without an evaluation of the law. You may need to write this for the benefit of a client, a lawyer, or an official. The essential elements of a legal memorandum are as follows. Introduction. This section is useful in laying out the context of the memorandum. You should, in brief, describe the basics of the dispute and the legal context. This will help when reading the statement of facts and issues, and is particularly useful in complex situations. This section can be kept brief, as the other sections will elaborate upon the points. You must also indicate who the memorandum is addressed to, who it is from, the subject matter in a sentence, and the date of the memorandum. Subsequently, this will be easier to refer to in discussions. Statement of facts. The statement of facts takes on significance in the memorandum. It is important to focus on facts that are material and relevant to the dispute or query at hand. It is also important to analyze the facts, and even if a particular fact does not seem particularly important, it might have significance at a subsequent point. In such a case, ensure that this fact is reflected in your statement of facts. Further, in case of facts that are unfavorable to the client and are material, these must be reflected in the statement of facts. Statement of issues. The statement of issues in the legal memorandum states the relevant legal questions at hand, and also could include a brief answer to the issue. Formulation of the issue must be done carefully, to ensure that the legal questions are addressed. It would be detrimental to leave out an issue that has significance to the dispute in question. This should be a brief and concise statement, and the response should also be in the same format. This is because the lawyer or client may want, at a glance, to be able to tell in brief what the position on a particular issue is. The explanation of the law and the reasons will be presented in the next section. Discussion. The discussion involves the application of the law to the facts. This section may be divided according to the issues that you have identified, and the discussion can be placed in this context. In approaching the discussion section, you should use the IRAC approach learned in Unit 1 previously, where you analyze the law and apply law to facts in order to reach a particular conclusion. In the discussion, you must be careful with the use of authority and precedent in order to substantiate and analyze issues. You must have regard to the ratio in obiter, in cases that you use in cite, and must be able to distinguish them as appropriate. This is also where a case brief regarding cases you will use to discuss the issues is particularly helpful. Conclusion. The conclusion you reach must reflect the overall analysis of the law and the facts to the case or dispute at hand. You can also make recommendations regarding what are the steps to be taken with regard to the client, and how to advise him, her on going forward. 3.5.3 Legal pleadings and drafting. Legal pleadings and drafting are a different type of legal writing from the case brief and legal memorandum that you have studied. Legal pleadings are the documents that are submitted to court, presenting arguments on behalf of your client. In this sense, they are quite unlike a memorandum, which presents a more comprehensive picture, and includes the positive and negative aspects of a case. Legal drafting is the skill that is required in drawing up contracts, deeds and other legal documents that are not necessarily being submitted to a court for advocacy. These documents will have the rights and duties of both parties in are then negotiated upon. Pleadings. Legal pleadings are the statements that each party makes to put forward its case. In the course of civil proceedings or litigation, the idea behind a pleading is to afford the opportunity to present the facts and persuade the judge in the favor of your client. Hence, it is an extremely important legal document and the strength of your argument, and ultimately your case, can rest on the pleadings. It is a document that puts forward your interpretation of the facts and law in a manner to argue your case before the court. There are formal rules that regulate the pleadings before a court, which are contained in Order V of the Code of Civil Procedure, CPC. The most important aspect of this is that if a plea of fact has not been raised, it is difficult to raise it in later proceedings. Hence, there must be utmost detail in the facts and analysis presented to the court upon submission of the pleadings. On the other hand, if the facts are provided for in the plea, but the legal argument is not made out properly, this would not be a bar to bringing up the argument later. The aim of the pleadings is to ensure that the material facts are placed on record, and so all facts that are pertinent to your claim must form part of the pleadings. There must be a clear statement of the cause of action, or the grounds of defense. This means that all facts that would directly impact the conclusion of the court must be pleaded necessarily. These facts that relate to the cause of action must be clearly indicated, as opposed to the other facts that are not directly related to the cause of action. The pleadings should be concise and to the point. Also, the facts must record all the relevant details and must be specific in nature. The plaint should not be ambiguous and vague. Further, there should not be inconsistencies between former and later pleadings, i.e., you should not contradict your interpretation of the facts or law in a subsequent pleading. In case you need to alter a pleading, this can only be done under Order VI, Rule 7 of the CPC, which stipulates that this can be done only if there is a new claim or fact. It is preferable that your original pleading contain all the facts, and this must be drafted with due care. Drafting. Legal drafting is a technique or type of legal writing that is used in order to record information between parties. Invariably, this includes documents such as deeds, wills, contracts, and other agreements. These legal documents testify to certain facts, as well as rights and obligations. An example of this is a contract for the purchase of 100 sacks of potatoes by Arjun from Ram for 500 rupees per sack. The basic elements of this contract would be the parties, the purpose for the contract, i.e., the sale of potato. Further, any additional specifications of the parties, such as what happens in case of delay or breach of contract, damages, etc., would need to be written into the contract. Such a document would be negotiated between the parties, and you would need to record this in written format. You would also need to put this into writing in such a manner that it is clear and unambiguous to the parties, in case there is a disagreement regarding the terms of the contract subsequently. An example of the contract would be as follows. 1. Arjun, aged 35 years, residing in house 33, X village, agrees on date 2. Buy from Ram, aged 32 years, residing at house 87, X village, 100 sacks of potatoes. 2. The price to be paid for each sack of potato will be 500 rupees, 500 only. 3. In case Ram is unable to supply 100 sacks in 3 months from this date, 28 July 2008, then he must pay Arjun a penalty of 100 rupees per sack. 4. In case there is no supply of potato for 4 months from this date, the 28th of July, 2008, then Arjun shall be paid a penalty of 400 rupees per sack of potato. 5. In case of any dispute regarding these terms, the headman of village X shall be appointed to arbitrate. Signatures of parties and witnesses to the agreement. There should be clarity in the language and the terms that are used in the contract. Also, all possibilities should be considered, such as default, non-payment, breach of contract, and other possible situations. These must all be factored into the contract, which should be drafted in as clear and methodical a manner as possible. 3.6 Summary. The essentials of good writing hold good for legal writing as well. These are keeping writing simple and clear. Also, ascertaining for whom and why you are writing. Legal writing requires detailed preparation in the form of legal research and proper organization, which includes making notes and outlines of research. An important part of legal writing is citing to authority. These are essential tools in the process of writing. There are different types of legal writing, such as memoranda and legal pleadings as well as drafting. Case briefs are important to cohesively put together the case law on the point and clarify issues. A memorandum follows a different approach from the case brief, in the manner of approach and the information contained in it. A legal pleading is an advocacy document and the approach to this is different from the case brief or the memorandum. Drafting, which includes contracts and other agreements between parties, also follows a different form and structure from the previous legal documents. Thank you for watching. We will see you in the next video with the next chapter.